Good morning, good morning. Welcome to the SC Police Association. My name is Derek Richardson, President of the SC Police Association. And with me this morning, I have our colleagues from the Trinidad and Tobago Unified Teachers Union, in the form of Ms. Marshall Huggins, the second Vice President, and Mr. E.D. Stewart, who is the President of the Trinidad and Tobago Nursing Association. Right? On my left, I have the first Vice President of the Association, Mr. Videsh Bhagwandin, and the General Secretary of the SC Polo Association, Mr. Robert Otley. The reason for calling this news conference today is to inform the public of a landmark judgment that was received on the 30th of this month. This judgment came from the Privy Council. And we thought that with the importance of this judgment to the total jurisprudence of Trinidad and Tobago, we had to make it known to the public exactly what transpired in a matter which originated since 2014. This matter was when the Royal Bank of Trinidad and Tobago decided to outsource its in-house security, 42 of the estate consoles attached to the Royal Bank. The association then took up the matter at the Special Tribunal. The Special Tribunal heard the matter. The Royal Bank submitted to the Special Tribunal that because the Estate Polo Association did not have a branch board, then the Estate Polo Association does not have local standing to hear the matter, to represent, in fact, the interests of the estate consoles. That was despite the fact that, according to the law, the only persons who can, or the court, is the Estate Polo Association. The Special Tribunal also, on its own, raised the point that they do not have the jurisdiction to hear this matter. That was, of course, despite the fact that it was reported to the court via the Minister of Labour. So here you have a situation where the Minister of Labour would have sent something to the Special Tribunal for adjudication, yet the Special Tribunal was basically saying to the Minister of Labour, we don't accept this matter. The association sought relief through a judicial review. That matter was handled by Mr. Anthony Bullock. It went to the High Court, and the High Court agreed with the Special Tribunal that the association must have a branch board because, according to Section 38 of the Supplemental Police Act, it says that the association shall run through branch boards and a central committee. We disagreed vehemently with the decision of the High Court and sent it in 2019 to the Appeal Court. The Appeal Court heard the matter, and the Appeal Court agreed with the association on both points. One, that the Special Tribunal did have the authority and the responsibility to hear the matter, and that the Estate Police Association is the body to bring this matter to the attention of the court. We thought at that point in time that the matter was done. Because what happened when the judgment at the High Court was pronounced, we had companies who would have, didn't have branch boards, who would have withdrawn matters based on a judgment that the judgment said, okay, there's no branch board here, and all the matters that we had before the ministry was then withdrawn. And then we had instances in companies where there were pressure put on the branch boards now, where they normally would have worked some extra hours and all of that. They started to pressure them into coming out and mashing up the entire branch board. So they can now claim that the EPA has no local standard to represent the officers. So we had to take some action, and that is one of the reasons why we sent it to the appeal court. The appeal court agreed with the association in its entirety. And we thought that, okay, this is the situation here now, that we will move forward and represent all officers. But in a shock move, the special tribunal, not the bank, the special tribunal, the place where the law sends us, including shooter, including nurses, all the police, fire, prisons, everyone. That's where the law directs us according to Civil Service Act. Right? According to the Supplemental Police Act, that's where we go. The special tribunal took the decision to ask for leave to appeal this matter at the Privy Council. And I want this point to be very clear that RBC, the bank, never was party to these proceedings. So, the special tribunal decided that they would send us to England. Right? I want to point out here an incident which happened immediately after this judgment. The special tribunal got leave to go to the Privy Council. The association had a matter involving allied security. Walked into the court, we have a branch board at allied security, walked into the court, and there the chairman of the special tribunal said that he does not agree with the ruling of the appeal court, and they have applied for leave and granted leave. As such, he would not be hearing any matter involving the Estate Police Association, and promptly walked out. We would have applied to the court for the verbatim notes. We saw the verbatim notes. It was never released to us. Okay? So we went, in fact, we had to find the resources for our attorneys, Douglas Mendes, Anthony Bullock, and Clay Hackett, to find their way to England to represent the interests of the Estate Police Association and all Estate Police as a whole. As a matter of fact, justice. That is what they went to England to. The matter was heard on the 29th of February this year. And the judgment was given on the 30th of May 2024. 3 months later, Privy Council Appeal number 0043 of 2022, before Lord Briggs, in fact, Lord Hamblin, Lord Legat, Lady Rose, and Lady Simler, appearing for the Estate Police Association, as I mentioned before, would have been Douglas Mendes, SC, Anthony Bullock, Clay Hackett, instructed by the Chantry Chambers of Port of Spain, and the appellant would have, handled by Thomas Rowe, KC, an English attorney. English KC, in fact. Instructed by Charles Russell, Speechless, London. So what was before the Privy Council was whether or not the Estate Police Association has jurisdiction to hear or to in fact to represent the Estate Police members at RBC in this matter, and whether or not to hear the matter. The court, the special tribunal, as a matter of fact, conceded on some points, but they sought to introduce to the special tribe, the Privy Council, matters that they didn't bring up at the lower courts. So as it were, they would have been seeking to bypass local jurisdiction, right, and go straight to the Privy Council to ask for them to adjudicate on a matter which they never brought up. Of course, the Privy Council rubbished their claims. And the Privy Council agreed with the appeal court in total, meaning the Estate Police Association can represent officers where there are no branch boards, and that the special tribunal can hear this matter. And also, well, of course, the special tribunal would have also considered, because this was pronounced at the High Court on the appeal court, that the special tribunal is not a court of superior records, and its decisions can be appealed for whatever reason. And we want that to be altered, that the special tribunal is not a court of superior records, and its decisions can be judicially reviewed for any reason. This Privy Council didn't just deliver a judgment. It's our opinion, if when reading this judgment, the Privy Council sought to correct and to alarm of the special tribunal in bringing this matter here. If I go through this with a law, I think it's important that you get some context of what the Privy Council is saying. The Privy Council, in dismissing the appeal, section in paragraph 39, sorry, paragraph 29, 28 in fact, 28 and 29. This leaves the issue of whether the special tribunal is wrong to decide that it did not have jurisdiction to determine the dispute referred to it by the Minister of Labour. As stated in paragraph 11, the reason given by the tribunal was that the association could not represent the estate constables in their dispute with the bank when, at the time of their dismissal, the branch board had not been established. On this issue too, the board did not find it necessary to call upon the counsel for the association. So this point was so frivolous that they didn't even have to call on the association representative, counsel for the association, Douglas Mendes. 29. Even if it had been correct, the association could not represent the estate constables, it is by no means clear that this will deprive the special tribunal of the jurisdiction to hear the dispute between the estate constables and the bank. The dispute was referred to the special tribunal by the Minister of Labour under the provision of Part 5 of the Industrial Relations Act as incorporated in Section 40 of the Supplemental Police Act. Section 42 of the Supplemental Police Act requires the special tribunal to hear and determine such disputes. On its face, therefore, the refusal by the special tribunal to do so was a breach of its statutory obligation under Section 42. Here we have the highest court in the land pronouncing that the special tribunal would have breached its statutory obligation under Section 42. By this way, but that as it may, the tribunal ruling that the association cannot represent constables of an estate unless a branch board has been established was obviously wrong. We get to section 39, paragraph 39. The conclusion is sufficient to dispose of the appeal, but the board does not think it right to part with this case without considering the role played in this proceedings by the special tribunal. So they didn't think that just delivering a judgment saying that we can represent the estate police and that the special tribunal is a place where that we have to go to. They decided to examine the conduct of the special tribunal in these proceedings. And here what it says. The tribunal has participated in the proceedings in a manner to be expected of an ordinary litigant engaged in an adversarial dispute with another party. Before Mr. Roe Casey appeared on its behalf at the hearing of this appeal, no thought seemed to have been given by the tribunal to the fact that it is not an ordinary litigant but a judicial body. There is an obvious concern that acting as it may, as it were a party with an interest in the outcome of this case, is inconsistent with that role. The concern is greater when the result of the proceedings in this matter will now send the matter back to the tribunal for further jurisdiction. I want this section, this paragraph 39 to sink in to what the court, the Privy Council is actually saying here. I'm going to read it over. There is an obvious concern that acting as it were, as if it were a party with an interest in the outcome. The only party that had an interest in this would have been the Royal Bank of Trinidad and Tobago, who never participated. The question must be asked and answered. Why did the special tribunal appeal this matter to the Privy Council? Whose interest was the special tribunal serving? Was it the bank? Because it certainly cannot be the state police officers who come before you for justice. Is it that the money that was expended by the special tribunal to go to the Privy Council came from the pockets of taxpayers for the interest of a foreign bank? Where is the national interest in this? How? The first question when it came and we sat down as an executive to discuss that, and we recognized that the bank didn't have no part in this. So we asked the question, what is the reason for the special tribunal appealing this matter to the Privy Council? How could the taxpayers be expected to fund this? After the appeal court will have ruled. After the appeal court will have ruled. This is thousands and hundreds of thousands of pounds. You have to engage King's Council. You have to send people to England. You would, at the appeal court, they would have even, we haven't gotten cost. We got cost there. So the bank, the Privy Council, went on. Position in principle is the heading. This is an area of practice which perceptions have evolved. It may once have been regarded as a matter purely of choice for a court or tribunal whose decision is challenged in the proceedings for judicial review or on a statutory appeal, whether actively to oppose a claim to adopt a neutral role. The tribunal had only to bear that in mind. If it chose to actively to oppose the claim, it would put itself at the risk of an adverse order of cost if the claim succeeded. In the opinion of the board, this is no longer a sufficient statement of the position. What has for some time been a usual practice of the tribunal, if it takes part at all, will adopt a neutral stance in the proceedings, and all the court had, the tribunal had to do was adopt a neutral stance. You are a judicial body. It says in 57, a court or tribunal has no interest of its own, any more than an individual judge in trying to prevent a successful challenge to his decision. Its sole function is that of an independent and impartial adjudicator on disputes that come before it. The tribunal acts inconsistently with that function and compromises its independence and impartiality if, in effect, aligning itself with the interests of the successful party to the dispute. Has aligned itself with the successful party. That party would have been RBC. And then go to the meat, where we come down to paragraph 59, 60, 61, 62, and ultimately 63. In its written case for the appeal, the context of his request to raise a new issue, when they try to raise a new issue, the special tribunal observed that the judicial review claims can take a long time to resolve. The tribunal gave the present case as an example, pointing out that it reached its decision in January of 2018. What the tribunal did not acknowledge was that its own conduct has been the main cause of the regrettable delay. Instead of determining the dispute referred to it by the minister as it was required to do, the tribunal took it upon its own self to question the standing of the association to represent the estate constables, and decided that the association was incapable of doing so for a reason that was manifestly bad. To correct that error, the only option open to the association was to bring a claim for judicial review. Not only did the tribunal actively oppose the claim at every level, but it sought to argue that its erroneous decision was immune from challenge on the ground which now concedes were unsustainable. So here, you want to make a decision, and then you want them to come now and make you immune to challenge. You want to do what you want, and then you want to say, I made that decision already, so it can't be challenged. Paragraph 60. The concern raised by the tribunal role as an active party to these proceedings might have been avoided if the bank had taken part in the proceedings and defended the tribunal's decision to the extent that it could reasonably be defended. It is unclear why this did not happen. There is no evidence to show whether the claim form was even served on the bank. So there is no evidence that this claim form, that goes to the appeal court, to the Privy Council, was even served on the bank. So is that the bank have no knowledge whatsoever of this? If it is not already by the practice, the board agrees with the counsel for the association that when any decision of the court or tribunal is challenged in proceedings for judicial review, it is desirable that the claim form should be served on the other party or parties to the underlying dispute, who should be invited to join the proceedings. In the absence of the bank, when the claim would be otherwise have been entirely unopposed, the board does not criticize the tribunal for appearing in the High Court and on the appeal of the association to the appeal court, whether in the manner of its participation in the proceedings below, the tribunal maintained an appropriately neutral stance. It did not matter on which the board is well pleased to comment. However, section 62, where, however, in the board's opinion, the board being the Privy Council, the tribunal clearly lost sight of the principles of impartiality and neutrality, which should give its conduct as a judicial body its decision to bring this further appeal. So what I was saying here, we have no problem with you when you went to the High Court, when the association would have gone to the appeal court to be party to this. But it clearly lost its way when they decided on their own to bring it to the Privy Council. Exercising the right of a litigant to appeal to the Judicial Committee, even though its appeal raised no arguable point of law of general public importance, the tribunal substantially prolonged these proceedings and put the association to yet further expense. It did so on a point of argument which the board found to be devoid of any merit. Conclusion. The appeal is dismissed. The Court of Appeal further therefore now stands remitting the matter to the special tribunal to hear the dispute. Any further hearing should take place before a fresh panel of the tribunal, which, if possible, does not include any member who heard the dispute previously or who has any involvement in these judicial review proceedings. So anybody who at all is associated with this, the Privy Council is saying you should not be able to listen to this matter and adjudicate on this matter. Trinidad and Tobago, according to the Civil Service Act, the special tribunal is not constituted unless the chairman of the special tribunal is present. Right? This matter here. So, Mr. Lawrence Achong is the person from the first day that this matter went forth. He was the man behind, he was the chairman, in fact, of the special tribunal. Now that has been referred back to the special tribunal, he cannot sit to hear this matter. Who then sits? Who then sits? Because the board, it can't be constituted unless he is present. So who then sits? This is a legal conundrum for the government of Trinidad and Tobago. Civil Service Act says something. Privy Council is now saying, listen, for impasse, because they question the impartiality of the special tribunal. And say, listen, we can expect you now to go and be impartial in this matter. How could you? Bias. You take this upon your own. The bank could ask the bank. The bank is not party to this. Right? Why? The Privy Council is asking this country to examine the special tribunal and the conduct. That is what this judgment is doing. And said before, the Privy Council could have just delivered a judgment and said, hey, I say police ought to win. But the depth of which they went into this judgment here speaks to a serious concern by the highest court in the land as to how and why the special tribunal conducted itself in this matter. We have 42 West Sea constables who were sent home, were dismissed. Royal Bank. Then you have a further set, because after this, you have another set of officers they sent home after that. Right? Have been waiting 10 years to even start the matter. So we have to ask for expedited hearing. But the expedited before who? Before whom? Before who? How could tutor? How could nurses? How could anybody going before the special tribunal expect to have an impartial hearing? Because the highest court have already said, listen, hey, your operations of these special tribunals needs to be examined. So, the first vice now pointed out to me, the association does not feel very comfortable at all going before the special tribunal. And in fact, none of the associations have been, for years, have been raising flags about the operations of the special tribunal. Point in case, we have a judgment, Central Bank versus the Estipodia Association, waiting judgment for 2 years now. 2 years. The Privy Council delivered a judgment in 3 months. 3 months. Right? 2 years. We wrote to the registrar and said, please, What is the situation with the judgment? Because we have outstanding here, we cannot go forward with the negotiations at the central bank unless this matter is disposed of. The matter was heard for 2 years, we can't get the judgment. No answer. Then you have a judgment that that same court gave us. ST 13 of 2012, G4S versus the Estate Police Association, where they said that the estate police were not workers under the Minimum Wages Act and not entitled to overtime until after 12 hours would have passed. They also pronounced that the security officers are not workers under the Minimum Wage Act and also not entitled to overtime after 8 hours, but after 12 hours would have passed. We can handle our business with the ST police. We have a way to do that. What we need to bring to the attention of the public is that under the sectorial order, Minimum Wages Act, Minimum Wages Order, sectorial order containing Minimum Wages Act, it is specific that the security officer falls under that particular act and that particular order, and that overtime is 8 hours. However, the Special Tribunal does not have any jurisdiction to pronounce on that sector of workers because they do not fall under essential services. Yet, he put it in a judgment, underline and emphasize that even though the security officers is not party to this matter, he had pronounced on it. He pronounced on it. The Ministry of Labor put it out on their website, and for years I've been saying that security officers are not cannot get overtime until 8 or 12 hours have passed. Funny thing about that is that in the same court, in Tobago, Milsule versus Hamadi Ajakam, but there was a judgment coming out of Tobago which said that the security officers have taken overtime after 8 in 2015. In 2016, he gave the judgment unprovoked because we made no submissions about the security officers. So how did it come in? And in 2023, they had the OWTU picking up a matter for some security officers in Hella, and the court now pronouncing that they are entitled to overtime after 8 hours. Why? Yes. Why did the Special Tribunal make such a pronouncement unprovoked? It does not come before you. It's come like if you're saying that you want to represent you making a determination on a body of people that you have no jurisdiction over. How and why?
But the one you had jurisdiction for is here.
Yeah. Exactly. So and that is it. The one that you have jurisdiction over, the state police, you come and you went to the court and say you have no jurisdiction over it.
Yeah. But you do have
right? If we don't call, and I want to say it here, we are calling for the immediate resignation of the chairman of the Special Tribunal. If he does not submit his resignation by Monday morning, we are calling on the Prime Minister to remove the sitting chairman of the Special Tribunal in the interest of justice, in the interest of it. Everything has been said is being said in the judgment here. Anything that needs to be said needs to be said in the judgment here. How can you, as an impartial, you're supposed to be impartial, you're a judicial body. You've been found wanting. You took the matter. The SAPO Association didn't take the matter. You took the matter to the Privy Council. And the Privy Council said, hey, examine the horns. Treat on board. So I want to pause for our calls, take any questions, and you may have.
I was going to ask, where do you go from here? In the event that because the special tribunal demanded the Privy Council.
Yes, they did. Verify that.
So, you talked about your dealing of conundrum. With the Privy Council saying one thing, we have a person who's appointed by a former government minister and all of that.
Yes.
Where do you all go from here? There's no guarantee that what can you all do to guarantee that he resigns or he is removed from that position in order for justice to be served, as you're asking?
But public pressure. He must be convicted in the court of public opinion.
But there has been public pressure. Anything happen?
Yes, I'm not sure the police have done. This is a judgment coming out. And if there's any fairness, if there's any sense of wanting to protect the citizens of Trinidad and Tobago, then the government has an obligation to act.
Where are the 42 officers?
They are all over suffering. All of them got no jobs. They couldn't find employment in any comparable jobs. Some of them were sick. Some of them all over the place. You try to get one or two of them, they're hustling everybody here, hustling them. Frustrated. And it's not just 42, because after they sent home this 42, they sent home a further. So we were waiting because we couldn't take the matter up for them until this judgment. So it's a whole set of officers that were denied the right to representation by the special tribunal, who we go to
For justice.
for justice.
So after 10 years, we're now able to take up their case, but there's no clear path because
Expeditiously. The speed at which Felix was removed is the speed at which that this man was removed from.
Yeah.
So I guess,
The cabinet.
next time, obviously, reconciliation, obviously, we have to sit for a special tribunal, okay? The chairman in charge. It should raise an issue of impartiality, so it's not a matter that we can see the court again. Challenge it.
Well, the Privy Council said its conclusion that anybody who's associated with this matter cannot sit and hear it.
So what I'm saying is that another legal challenge should the chairman of the essential services. Because obviously,
Well, of course.
according to the act, it doesn't even mention a substitute.
Yeah.
It just
It does.
says that
Yes.
the tribunal is
Is him and two others.
Correct.
Mhm.
So it's almost like a Privy Council saying now.
Remove it. Remove it.
Yeah.
Remove it.
Correct.
Yeah.
So is there, if it doesn't happen, I mean, anything else?
Of course, yeah, the legal, of course, all of us will do what it is necessary. Yeah.
I mean, after a judgment like this, where the Privy Council questioned the independence and the integrity of the special tribunal, we believe that finally, that if Mr. Achong does not resign, that the powers that be would remove him. Right? Because it's a stain, a judgment like this is a stain in the country, and it's really a slap in the face for all workers, for all estate police, right? And if you go to a body to address an issue, that body should be independent. And clearly, by this judgment, they are not.
No.
There's another dimension to this that we submitted. Here the question is, the government of China, they will study the content of the Dr. Nina is the government of China legal? face of this judgment standing?
Yes, it would be. It would be. And that's the point we don't make. There's a judgment by the highest court of the land, which stands now as law.
So in a case like this, the industrial court, the president is the vice president, and then there's the chair. Wasn't there no one or nothing in place to examine that decision?
Well,
Or was it that the special tribunal is not operating independently for the rest of the industrial court?
the special tribunal is not part of the industrial court. It sits in the industrial court, right? But it's not part of the industrial court. The chairman basically is the jefe. He is the president, he is the chairman, he is the chief butler, he's everything. Remember, he appoints the two persons
To sit with him.
to sit with him.
Yeah.
That's the level of power that he has. So whosoever he takes, if he got to take you off the street and say, come and sit down with me, he could do so. You have a degree in economics, you can say, okay, well, partner, come and sit down, man. Right? That is the kind of power. And see, Labour has been asking and prodding people, prodding the government to look at these things, amend the labour laws. Nothing has been done. Why? Why? We have to examine beyond this particular judgment. I want to thank the special tribunal for taking it to the Privy Council. Yeah.
So the original matter started 10 years ago, right?
10 years ago.
Any idea what's happening for you? So if your original process is and then
You can't see.
10 years later,
You can't see. Because it all depends on how fast the government moves, how they move to remove those persons who have been parties in this.
What steps have you all taken to ensure that, it was on the 30th,
Mhm.
right? What steps are you all taking to ensure that?
Well, yeah. So this media conference is start, right? And we know our sisters and brothers and sisters in the labor in our labor will be making statements on it, right? The government is in receipt of this. The government is in receipt of this. The Attorney General, right? The Chief Justice, everybody is in receipt of this. It is there now to do their duty. If they don't do it, well, of course, our lawyers will have to step in, and we want to thank, really thank somebody we consider to be a true patriot and a true champion for the downtrodden, a true champion for labor, Douglas Mendes and Anthony Bullock. Also, a man who is not mentioned at all, a man called Harrison Thompson. He was the industrial relation consultant who took on the challenge for those officers to start this matter. When it reached the point of the High Court, that is when some Bullock and then took over and said, listen, this is wrong. Some Mendes and I got involved, and that is how this thing reached where it is.
but are you going to
The thing is that we will be guided by the directions of our attorneys, right, in this matter. Mr. Bullock could be here, Mr. Mendes is out of the country, right? But this was too important a matter to allow it to just slide.
Seeing that you all have representative of the business and so I'm wondering, because I know we all have this special tribunal sitting adjudicating 4% and all of that prior to this. So I'm wondering how this affect you all and why you all thought it necessary to be here.
Just come over.
Do you all want to shift seats?
Yeah.
Okay, sure. right. Good morning.
Yeah.
Please identify yourself from the right. All right, I'm Marsha Huggins, Second Vice President of the Trinidad and Tobago Unified Teachers Association. We felt it important to be here because this is a landmark judgment. It also speaks to the deficiencies of the Industrial Relations Act as it relates to public officers in terms of the kind of justice that we are able to get through the court and through the persons who sit there. So yes, we would have gone through all of the process of the special tribunal last year and all of that, and that judgment, those things have come through. The PSA still has a matter before the court with regard to that same thing. So we are waiting final judgment on that. But it does speak to the deficiencies, how the rulings or the actions of the special tribunal impact on all public officers, not just estate police, not just nurses or teachers, but all of us. So we stand in solidarity with our brothers in the Estate Police Association because of the impact, the implication that a judgment like this can have. It will have a ripple effect throughout the system. So that's why we are here, standing in solidarity with them.
Pleasant morning. E.D. Stewart, President of the Nurses Association. Firstly, let me say I want to extend our congratulations, first and foremost, to the Estate Police Association. This is a tremendous victory for the labor fraternity. It's not only for those 42 workers who were dismissed, not only for those workers who were subsequently dismissed from Royal Bank, and not only for the families who were negatively affected by their dismissal, but it's definitely a victory for the entire labor fraternity. You know, in the labor fraternity, union leaders, union executives are often gone unnoticed and not awarded for national awards. But this is this type of victory I would want to recommend my colleague and the executive. Really, the government see these types of things don't happen very often, and it really cannot be lost on the national psyche what has transpired by the victory that the Estate Police Association have won in the highest courts of this land, and we really want to commend them tremendously. Secondly, from the association standpoint, we are seeing a growing trend where we don't only have to fight on behalf of our members, the employer, whether those employers are public or private. That is not our only battle. It appears on a continuous basis that we have to fight against the courts who are set up to protect the citizens of Trinidad and Tobago. And it's really unfortunate that we have to be going through that. The Estate Police Association have to expend enormous membership funds to safeguard the interests of members when it is the courts that is the responsibility rests on them. So it's really a sad day in Trinidad and Tobago, but it's a positive day by these victories. And we must also place it into context. The recent judgment against that very tribunal with the PSA judgment, those two things combined, we must analyze it in that framework where courts have repeatedly indicated that that special tribunal is not operating with the impartiality, with the fairness that it ought to be operating with. It is making pronouncements, and that particular judge, that particular individual, former minister, is making statements even before the case starts. He's letting you know he would not be impartial. That is craziness. That is absolute crazy. And we are seeing it on his bold face in his comments. And this is why we really must be mindful of this judgment and all cases. And finally, the association, again commending the association for having the testicular fortitude to go up against giants like the special tribunal. But it comes at a cost. It comes at a cost to the association. It comes at a financial cost to the membership. And it comes at a cost to the state. So when we look back and we analyze and we hear all these mounting costs of legal bills that the Attorney General have to sign off on, that we the taxpayers have to pay, this is some of the reasons why they have to pay these mounting legal bills. And the Privy Council is saying, this is frivolous. Why you are bringing this to us? This is frivolous. This has no merit. And you are bringing these cases with no merit to the Privy Council, mounting bills against not only the association, but also the states. One could only understand that even RBC did not see merit in this case, did not see merit, but the independent body where there's no merit is taking this to the Privy Council. So again, we condemn and we also call for the removal. The Privy Council is far too diplomatic to tell a country that you must remove your judges, your sitting judges, dispose of that special tribunal, who it composed of. But we are not so diplomatic. We are saying the government must remove Larry Atcham, and we expect in the coming days, other sectors of the labor fraternity would also be calling on Larry Atcham to be removed immediately. And it cannot be difficult, because for the EPA case to move forward, he cannot be sitting there. And he has to sit there because he is the chairman. So the government has no choice but to remove him. Their hands are tied. They have been holding off for a number of years. Even when you go to the court, and I have seen it with my own two eyes, he begins the court matter, tells you how he's going to rule, and tells you you have a losing case up front. Not in so many words, but he tells you that. And then he sleeps for the rest of the case. And then wakes up at the end of the case and rules how he told you he was going to rule in the beginning. This is Larry Atcham. We have seen it. Every union is witnessing this. So it's about time when the EPA, and I know they will do what they have to do, and we will support them every step of the way. We expect when this case goes back to the special tribunal, he would not be a factor. He cannot. The Privy Council have stated in so many words. So we expect the die has been cast. The international court has ruled against him, and he must do the honorable thing and resign.
Of course, it's yet to be assessed. Of course, it's yet to be assessed.
Yeah, there's no indication from the judgment about cost. So I want to just go back a little bit to the actual individuals who were harmed in this decision. Those officers, those estate constables who were working very hard at the Royal Bank when decision was made, right? What they had to endure 10 years of waiting to even start this thing. And so it is imperative, absolutely imperative, that the government moves post haste to remedy this. We cannot be going back to no long process for them to hear this matter. It cannot be. That would be the state encouraging wrong to continue an act of violence against its own citizens. This is what this was. So we are going to examine what happens in the next couple of days. We're going to see. We are going to once our call is not heeded, we will take the necessary action to ensure and to keep this up to the point where we are not going to retreat. Because I don't know tomorrow if there's any case with our because what matters, we have a couple of matters to come before the special tribunal. How could we go before the special tribunal now?
After this ruling.
After this ruling, not any matter. Cannot expect him to be impartial. We cannot expect him to be impartial, so we cannot go. Justice must is denied. Justice must only be done, it must also seem to be done. So I want to thank the members of the media and those listening. And I really want to make a plea outside there to all right-thinking citizens of Trinidad and Tobago. All those who sit in the Parliament of Trinidad and Tobago, the opposition, the government, the independents, everybody, to take heed of this judgment and ensure that Larry Acham was removed. Ensure that justice is done. That is what I said. Ensure that justice is done. The common man, the court and the special tribunal is the place where the man of straw, the common man who wants to get justice, can access the High Court. The access to the High Court are extremely expensive. He has to go there. If you go to the High Court and accept what to everybody, did you raise it? Did you raise it? Did you have prior? So how could you, even for you to take a matter to the High Court, look how money going to have to be expended? The provisions was made in law, and the persons who adjudicated upon that denied those persons the benefit of the law. So they cannot sit. Right? So thanks once again for coming, and we will see how it goes in the next couple of days. All right. Welcome.
Just stay on top, that's some cautions.
I think that's victory.
Yeah.